Okay, part two of our unit here on contract law is going to look specifically at some of the labor laws and antitrust laws that have been passed in this country that, again, have created this foundation for existing contract law in the U.S. So, generally speaking, when we refer to antitrust or labor laws, we're talking about laws that govern the actions of private businesses and corporations and ultimately protect the rights of individuals, both the people that work at those organizations and the consumers that consume their products and services. So, really, antitrust laws were passed in order to protect this process of competition with this ultimate goal of protecting the consumer. Basically making sure that there are strong incentives for businesses to operate efficiently, keep prices down, and then keep quality up. So this area of law in particular covers mostly private businesses, and in our field that means businesses like professional sports teams. But when we also look at labor laws through the lens of college athletics, we can look at labor laws in that they impact K through 12 school systems often. So this is a particular area that can impact a number of organizations in our field. And as you'll see here shortly, the Fair Labor Standards Act of 1938 is one that impacts most organizations in our field. And we'll look at a specific new law here in the state of Illinois that is likely going to have a major impact. Okay, so let's start with antitrust law first. So you can see here, in general, antitrust laws have been passed with this idea that we need to protect consumers, right? So this idea that we want to have competition in the marketplace so that there are strong incentives for businesses to keep up their operations in an efficient manner. And again, the whole idea here is that we keep prices low and keep quality up for consumers. So essentially, what antitrust law does is that it outlaws a few different types of business practices. It outlaws this concept of monopoly, and it also restrains interstate commerce. So you might be thinking, these are big words, Liz. Where did they come from? Are you talking about the board game? And I'm not talking about the board game. When we refer to a monopoly, we're basically talking about a situation where one supplier has significant market power. And because of that, they have the ability to raise prices or force out competition because of that. So basically, they're dominating because they're able to exclude. Some have argued that sports leagues themselves can operate as a monopoly since there are typically no competing leagues, not recently anyway. But courts have generally said that those sports leagues are natural monopolies and not purposeful ones, meaning that if another league wanted to try to compete, they could. They just may not be successful. So that's what we refer to when we refer to a monopoly. This concept of interstate commerce occurs when anytime a business crosses state lines. So, as you can imagine, most major businesses operate at this level. And when we refer to the restraint of interstate commerce, basically what we're talking about is any kind of limit to trade, sales, or transportation in reference to businesses that cross state lines. So you can think about college athletics in the vein of interstate commerce, right? Even though colleges might exist in one state, oftentimes those schools and those teams are traveling to other states to compete, right? So that's an example of interstate commerce. And what antitrust law does is that it says that there must not be restraint on interstate commerce. Okay, let's switch gears here and really identify one of the major antitrust laws that we have in this country, and that's the Sherman Antitrust Act. You can see this is a law passed quite a while ago, 1890. And again, the idea here is to really promote and protect this concept of free market capitalism that we've accepted in this country. And again, you can see there are two sections here of the Sherman Antitrust Act that really echo some of those terms we looked at on the last slide. You can see ultimately antitrust law is this collection of anti-competition laws. Basically, they prohibit anti-competitive business practices and really designed to promote and regulate competition. Excuse me. So, Section 1 of the Sherman Antitrust Act, as you can see, prohibits restraint of trade in interstate commerce. So, again, any activity which limits business transactions that cross state lines is what we're referring to in this context. Now, Section 1 only applies to businesses that participate in interstate commerce. So, if you're a recreation organization and you only do business in the state of Illinois, this doesn't apply to you, right? But those organizations, those sport and recreation organizations that do operate in that system where they're doing business across state lines, do need to be aware of this section. Section 2 here, as you can see, makes it illegal for those organizations to monopolize. Again, we identified this concept of monopoly on the last slide, where one supplier essentially has significant market power and then raises prices or forces competing companies out. Again, basically, sports teams in general at times have been argued that they are monopolies or they're acting as monopolies, and they've been tried or taken to court on these issues as well. But in general, they've been able to maintain the status quo because the courts have said they operate as natural monopolies. I did upload a recent case here involving the Sherman Antitrust Act. And this one's interesting because it involves the ticket site StubHub and them filing an antitrust lawsuit against Ticketmaster. Essentially, Ticketmaster and the Golden State Warriors, the NBA team, had entered into an agreement or contract together so that Ticketmaster could sell tickets for the Golden State Warriors. Take a look at this case. I think it's really interesting, particularly because you've got one company suing another company along with a sport or recreation organization. So, take a look at that case. It might help you make sense of some of the content here related to antitrust law. I know it can be a little bit technical, so that story might help make sense of things. Okay, so the Clayton Act is another really important law, this one dealing specifically with labor law. So while the Sherman Antitrust Act was passed to protect the process of competition for the benefit of consumers, making sure there are these strong incentives for businesses to operate efficiently, the Clayton Act was passed as a key piece of legislation that promoted and ultimately legalized the labor movement in this country. So you can imagine this is a pretty landmark piece of legislation. Prior to the Clayton Act, it was essentially illegal for employees in the U.S. to unionize, right? To come together as a group, collective, union, and then bargain with their employers. So historically, employers had challenged a union's right to organize as a violation of the antitrust laws that we just looked at on the last slide. So this particular law, the Clayton Act, basically creates the legality for unions in the U.S. And as you can see here, stated basically that humans are not commodities, right? That they have the ability and should be able to bargain with their employer for better working conditions, for better pay, all of these things. So the Clayton Act essentially legalized this labor movement, allowed employees to actually gain some power in the workplace. And prior to, they really just did not have that. It also created this concept of collective bargaining, where this process of negotiation between employers and employees. And again, with the end goal of reaching some kind of agreement surrounding working conditions. So not only did the Clayton Act legalize the labor movement, it also created this concept of collective bargaining in which employees and employers could actually negotiate over some of those big things. Obviously most professional sports leagues operate as unions. So the players have their own players' union in which they're able to then collectively bargain with their employers, the league, and the owners for specific things related to their working conditions. So, obviously, professional sports is just one example of that. Some of you might go on to work for companies that are also unionized, and you would have similar rights. Okay, I'm not going to talk a whole lot here about the National Labor Relations Act, but I just want to point it out to you that it went one step further basically than the Clayton Act and expanded protections for laborers under private employers. So whether or not a union existed, private employees also had a right to negotiate with their employer over some basic things like hours, wages, terms, and conditions. And it also created a system in which those private employees could form a union as well. So it's an important law in that, again, it takes kind of one step past what the Clayton Act did and opened it up to private employees that were unionized or not. Okay, so real quickly here, I think I want to talk about this law called the Fair Labor and Standards Act. So essentially, what the Fair Labor and Standards Act did was it created certain basic legal standards for employers in this country. I'm going to pause real quick here because I want to pull up a different slide. So hold on one second. All right, apologies, lost my slide there. So again, the Fair Labor oh boy, all kinds of issues here. Hold on. Okay, we're back in business. So the Fair Labor Standards Act, you can see here, this law was passed in 1938, and essentially the FLSA recognized that there are some basic standards in regards to wages, overtime pay, child labor that needed to be put down on paper and into law in order to maintain a high standard of living for employees. And essentially said, we're tired of employers taking advantage of their employees. We need to create some basic standards, some basic decency here. So you can see here, that's what the FLSA did. It created these standards related to creating things like the minimum wage, telling employers you have to pay at minimum this amount of money per hour to your employees. Created a system for overtime pay. It said if you're going to ask your employees to work beyond the normal 40-hour work week, then you have to provide them with overtime pay. These are things we obviously take for granted now, but prior to the passage of this law, there really were no laws that dictated these standards. So, important to note that this is a really landmark law in that regard. Also important to note that there are some things it does not regulate, and you can see those there, that employers have a lot more flexibility in regards to how they deal with some of these more fringe benefits. But again, it's important for you to be aware of these concepts as an employee, but also as an employer, right? Someone who is going to be managing people at some point in our field. It's important to know and keep up to date with what these standards are. And these standards change over time. Some of you might be aware of a new law that passed in Illinois here recently, which is going to increase the minimum wage up to $15 an hour. Now, this will happen over a period of time. There's a couple years here before the law has to be fully implemented. But this is a law that's got a lot of people talking in the state of Illinois, particularly in parks and recreation, and the impact that this law will have on the way they do business, right? Thinking about how many young entry-level employees, part-time employees that our field relies on in order to run our operations, and how this law will impact what it is that we pay those people and how that will impact our overall budget. So it's a really interesting law that has just been passed. So we still really don't know the ultimate outcome and how it's going to impact these organizations and their staff and the decisions they make surrounding programming and services. But again, this is an example of one of those things that we need to be aware of as practitioners, because they're likely going to impact the decisions we make on a daily basis. So I am going to upload a story here on how some local parks departments have been responding to this. So take a look at that when you have time. Okay, last slide here, and then I'm going to wrap up. The Fair Labor and Standards Act also has some exemptions, right? So there are certain exemptions that are common in our particular field that I wanted to highlight. So this first one is what we call the executive exemption, which is basically known as a white collar exemption. So basically, what it says is that employers do not have to pay overtime to salaried employees that meet a minimum threshold in regards to their salary. So the current threshold for this particular exemption is right around $35,000 a year. So the Fair Labor Standards Act says, employers have to pay overtime for employees that work beyond 40 hours. Well, this exemption says that they only have to do that for employees that are making less than that threshold, right? And as you can imagine, many jobs in our field come in right around this threshold, particularly for those entry level positions. So kind of an unfortunate exception for those of you that might be going into the field here soon that are going to be expected to work beyond a 40-hour work week, right? You won't qualify for that overtime pay because you're making at or above the current threshold. And the rationale here is that anyone that's working full time and enjoys benefits as a salaried employee and is making above $35,000 a year is already benefiting a great deal more than someone who is making less and working less, and therefore those organizations should not have to pay overtime. So, I think that's an important thing to keep in mind, again, as an employee, but also thinking long term about your place of employment and how that impacts the salary decisions that you make in terms of your organizational structure. This other exemption here that I wanted to mention is a trainee or intern exemption. So it basically tells us that K&R organizations don't have to pay people that are considered trainees or interns as long as they can show that they're providing training or education to that individual. So again, many of you probably are already aware of this since you've done some internships, or at least one. You probably have already realized that unfortunately you do not have to be paid as an intern, and that's because of this exemption. That essentially, if organizations can show that they're providing training and education, that they do not have to pay those employees. So those are just a few of the exemptions that I think are worth mentioning or to be aware of in regards to the Fair Labor Standards Act. Okay, that's all I have for you in this unit. So once you're done reviewing the video lectures for this week, make sure you take the quiz on ReggieNet, and then we will see you in class. Thanks. Have a good one. Thanks for hanging in there with my voice. I'm losing it.